Welcome back to the deep dive. I want to start with a riddle. In almost every corner of the law, the government punishes you for the damage you actually cause. You steal the wallet, you go to jail, you punch the guy, you pay the price. It's pretty transactional. Harm for punishment.
Right. Usually there's a body or a broken window or, a missing pile of cash. The crime is visible.
But then you have the doctrine of attempt. And attempt it's just bizarre.
Yeah.
Because with attempt, the government is trying to punish you for what you failed to do.
Yeah.
You're being handcuffed for being a total failure.
It really is the paradox of criminal law. I mean, if you succeed, you're a murderer. If you fail, you're an attempted murderer.
Yeah.
But the legal theory gets incredibly messy when we try to figure out why you failed.
Right.
Did you fail because the police tackled you? Or because the laws of physics made it impossible? Or, and this is the tricky one, did you fail because you just changed your mind?
And that's our mission today. We are going to look at the absolute limits of liability when the crime doesn't actually happen. We've got a stack of cases here. Stolen cloth that wasn't stolen, unloaded guns, a mathematician drilling into a bank vault. We need to figure out, when does a failed criminal still deserve to go to prison?
So we're going to build a diagnostic framework for this.
Yeah.
We have to look at impossibility, that's when the world stops you, and then abandonment, which is when you stop yourself.
Okay, let's start with the most brain-bending part. Impossibility. It just sounds like a logic puzzle. If I do everything I intend to do, but I make a mistake, a mistake about the facts or the law, and I end up doing something that isn't actually illegal, can I still be guilty of attempting to break the law?
That is the great divide. It's the old world versus the new world of criminal law. And to answer that, you have to look at the traditional approach. And honestly, the traditional rule is a bit of a mess. It tries to draw this line between two things, factual impossibility and legal impossibility.
Okay, so give me the working definitions, but, keep it grounded.
Okay. Factual impossibility is basically, I tried to shoot you, but the gun jammed. The law says, tough luck, you're guilty. The only reason you failed was a physical accident.
I see.
Legal impossibility is different. That's more like, I did everything I wanted to do, but the thing I did turns out not to be a crime, even though I really thought it was.
That distinction feels slippery. Let's look at the classic test case to see how it actually plays out. People v. Jaffa, New York, 1906. This is the case that drives law students crazy.
It's a classic because the outcome just feels so counterintuitive.
So let's analyze People v. Jaffa. First, what are the legally dispositive facts?
So, Jaffa is a fence. He buys and receives stolen property for a living, and he arranges to buy a specific roll of cloth. In his mind, it is stolen. He has the guilty mind. He absolutely wants to break the law.
Okay, so he buys the cloth. Where's the problem?
A problem is the timeline. Before Jaffa ever bought the cloth, the police had actually recovered it. They returned it to the true owners, and then the owners let the police use that same cloth for a sting operation to catch Jaffa. So legally, at the exact moment Jaffa handed over the cash, that cloth was not stolen property, it was just property.
So he thinks he's buying hot goods, but he's actually just buying a regular roll of cloth from its owners, basically.
Exactly.
And what was the core legal issue?
The issue was, can a defendant be convicted of attempting to receive stolen property if the property, in fact, was not stolen?
Common sense says yes. He tried to do it. He had the intent.
But the court said no.
What? He walks.
He walks.
What rule of law did the court apply? Please state the full black letter rule and break it down into its testable elements.
The court applied the traditional legal impossibility rule, and they looked at it like a math equation. It really has two elements, or two questions. First, did the accused complete the act he attempted to do? And second, would that completed act constitute a criminal offense?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, whether he completed the act?
Well, the court said yes. Jaffa purchased the specific goods he intended to purchase. He successfully completed the act of receiving them. So that element was met.
Understood. Now, what about the second element, whether that completed act was a crime?
And this is where his case fell apart for the prosecution. Since the goods were not actually stolen at that moment, the act of receiving them is not a crime. The court basically said, even if he believed they were stolen, you can't be punished for attempting to do something. In this case, receiving these specific goods. That isn't illegal. The act itself was innocent.
And after analyzing all the elements, what was the court's final conclusion?
The court reversed the conviction. Under this traditional view, it was legal impossibility. Since the completed act wasn't a crime, the attempt to do that act couldn't be a crime either.
That just feels like a massive loophole. You're letting a guy go who clearly wants to be in the black market just because the cops were too good at their job.
That is exactly the criticism. I mean, the Jaffe case represents this old objective view of crime. It focuses on the act. And if the act isn't criminal, the person isn't a criminal. And this is precisely why the modern view and the model penal code completely rejected Jaffe.
So how does the modern view fix it?
The modern view shifts the entire focus from the object, the cloth, to the subject, the criminal. It asks a different question. If the facts were as the defendant believed them to be, would it be a crime?
And in Javi's head, the cloth was stolen.
Correct. So under the modern view, Jaffe is guilty. The modern law punishes what it calls the dangerous mind. It says, we don't care that the cloth wasn't stolen. We care that you are the kind of person who is willing to buy stolen cloth.
It's a battle between punishing the harm versus punishing the dangerousness of the person.
That's the core tension of all of attempt law.
Okay, so Jaffa was legal impossibility, a mistake about the legal status of the goods. But let's look at factual impossibility. The reading has some visceral examples here that really test where the line is. I want to throw these at you.
Let's run them.
Okay. Hypo A, the corpse. A man is dancing with a woman at a party. She collapses in his arms. He thinks she's just passed out drunk, so he takes her to his car and has intercourse with her body. But it turns out she had actually died instantly of a heart attack. Is this attempted rape?
This is a famous and grim law school hypo. The analysis here points directly to factual impossibility. He intended to rape a living person. The fact that she was dead is just a factual circumstance completely unknown to him.
But you can't rape a corpse. I mean, it's physically impossible.
It doesn't matter. Under both the old and the new rules, he is almost certainly guilty of attempted rape. He did everything he could to commit the crime. The only thing that stopped him was a biological fact he wasn't aware of. The law basically says that's just bad luck for him, and he's still dangerous.
That makes sense if we're focused on dangerousness. But what about this one? Hypo B, the voodoo doctor. A man comes to the U.S. believing he has magic powers. He hates his neighbor, so he buys a doll, stabs it, and genuinely believes this ritual will kill the neighbor.
This introduces a third kind of weird category, inherent impossibility.
Because stabbing a doll obviously doesn't kill people.
Exactly. A reasonable person knows the means are totally absurd. Now, technically, under the modern view, he has the intent to kill. He believes he's a murderer. But most courts, and the model penal code, would likely dismiss this, or at least mitigate the sentence.
But why? If we punish the dangerous mind, his mind is just as murderous as the guy with the gun.
Yes, but he isn't publicly dangerous. He's delusional. Stabbing a doll doesn't threaten public safety in the same way shooting a gun does. The law is aggressive, but it usually doesn't want to waste resources locking up people who are, trying to kill with magic.
It's like the law says you're crazy, not criminal.
That's a good way to put it.
Okay, last one. Hypo C, the empty pocket. A pickpocket slides his hand into your pocket on the subway. He wants your wallet, but your pocket is empty.
This is the textbook definition of factual impossibility.
Yeah.
He intended to steal. He performed the act. He failed only because of a fact unknown to him. The emptiness of the pocket. He is always guilty of attempt in this scenario.
So, I reached into an empty pocket is never a defense.
Never. Because unlike the voodoo doctor, a pickpocket is dangerous. He just got unlucky this time.
This whole idea of getting unlucky with the facts, or I guess the victim getting lucky, brings us to our next major case. Let's analyze State v. Dams. This is about a gun that wouldn't fire.
This is a critical case because it really drills down on the concept of extraneous factors.
Okay, so first, what are the legally dispositive facts?
The facts are terrifying. Dams is driving with his estranged wife. They're arguing. He pulls a pistol, chases her out of the car and into a field, holds the gun to her head, and pulls the trigger. Click.
Nothing happens. He pulls it again. Click.
And the reason it didn't fire wasn't a jam. It was because, unbeknownst to Dams, the gun was unloaded. He claims he didn't know. He thought he was about to execute her.
So what was the core legal issue?
The legal issue is really twofold. First, does the fact that the gun was unloaded mean he didn't have the intent to kill? And second, can you even attempt to murder someone when it's factually impossible because you have no bullets?
What rule of law did the court apply? And please break it down into its elements.
They use the modern rule for attempt in Wisconsin. It has 3 elements. First, a specific intent to commit the crime. Second, acts in furtherance of that intent. And third, failure to complete the crime because of an extraneous factor.
Okay. Now for the elemental analysis. Let's start with the first element, intent. How do they analyze that?
They dismiss the defense's argument pretty quickly. Pointing a gun at someone's head and pulling the trigger is about as clear an indication of specific intent to kill as you can get. The court said the fact the gun was empty doesn't change what was in his mind because he thought it was loaded.
Right. Now, what about the third element, this extraneous factor? This was the tricky part.
It was. So the majority held that the unloaded status of the gun was an extraneous factor. It was a circumstance outside his control or knowledge at the moment he pulled the trigger. But the defense had a clever argument. They said, hey, that's not bad luck. That's Dam's own fault for not checking the clip.
I'm not a failed murderer. I'm just an incompetent gun owner.
Chuckles. Essentially, yes. The dissenting judge actually agreed with that. He argued that failing to load your own weapon is a personal intrinsic failure, not some extraneous force stopping you.
And after analyzing all the elements, what was the court's final conclusion?
Conviction affirmed. The majority found it was a classic factual impossibility, which is no defense. The fact that the gun was unloaded was a circumstance unknown to him. Doesn't matter why it was unloaded. The point is, he tried to kill. And in external reality, the lack of bullets stopped him. He is just as dangerous as if the gun were loaded.
So we've covered when you try and fail, because the world gets in your way. The gun is empty. The pocket is empty. The cloth isn't stolen. But what about when you try, and then you get in your way? You stop. You walk away.
That's the doctrine of abandonment. This is where we see if the law is willing to reward a guilty conscience.
Let's look at People v. Staples, the mathematician who tried to drill into a bank.
The driller case, yes.
What are the legally dispositive facts here? This sounds like a movie plot.
It really does. Staples is a mathematician, a smart guy. He rents an office directly above a bank vault. He's not just daydreaming. He studies blueprints. He brings in acetylene tanks, blowtorches, a heavy-duty drill.
So he's clearly prepping, but preparation isn't a crime yet.
Right. You can buy a drill. But Staples goes further. On a Saturday, he actually drills several holes through his floor, which is the ceiling of the bank vault. He's looking down into the vault. But then he just stops.
He walks away.
He leaves the tools there and goes home. The landlord finds the holes, calls the police, and Staples is arrested. His defense is fascinating. He says, I abandoned the plan. I realized it was absurd. I wanted to go back to my life as a mathematician.
And what was the core legal issue?
There were really two issues. First, had he even committed the act of attempt yet? And second, if he had, was his abandonment a valid defense?
So let's take the first one. What was the rule regarding the act?
The rule is that attempt requires an act that goes beyond mere preparation.
Okay, now for the elemental analysis. How did the court apply that rule to the act of drilling?
The court said drilling into the floor was absolutely it. That was the beginning of the breaking element of burglary. It was an unequivocal act. The moment that drill broke through the floor, the crime of attempt was complete. The bell was rung.
Okay, so the crime was committed. Now let's look at the rule regarding the abandonment defense.
The California court applied the traditional rule, which is that abandonment is never a defense once the attempt is complete. But they also analyzed it under the modern view, which looks at voluntariness.
Let's go to the elemental analysis for that modern view. How do they analyze the voluntariness of his withdrawal?
The court just didn't buy his story. They found his abandonment was likely due to the landlord finding his tools, or just a general fear of detection and apprehension. It wasn't a genuine change of heart.
It was getting cold feet.
Exactly. It wasn't this pure voluntary renunciation.
So what was the final conclusion?
Guilty of attempted burglary. He had crossed the line from preparation to attempt, and the court found his withdrawal wasn't voluntary in the way the modern law requires.
We've covered a lot of ground. Impossibility, intent, abandonment. I want to bring this all together for you, the learner. If you're looking at a messy fact pattern, how do you diagnose it?
Okay, think of it as a three-step checklist.
Let's have it. Step 1.
Step 1 is always the mental state. Before you look at the gun or the drill, look at the mind. Did the defendant specifically intend to commit the target crime? If they didn't have specific intent, you stop. They aren't guilty of attempt.
Got it. Intent is the engine. What's step 2?
Step 2 is the act and the impossibility check. They failed to complete the crime, so you have to ask why. If they failed because of a fact they didn't know, like the empty pocket or the unloaded gun in dams, that is factual impossibility. The result, guilty. It's not a defense.
And if they failed because what they did just wasn't illegal?
If they did everything they intended, but it simply wasn't illegal, like buying the non-stolen cloth in Jaffer, that is legal impossibility. The result here depends on the jurisdiction. Under the old traditional rules, not guilty.
Mm-hmm.
But under the modern rules and the MPC, guilty, because we focus on their dangerous intent.
Okay. And step 3.
Step 3 is the abandonment check. But this is for when they stop themselves. First, you ask, did they cross the line for mere preparation? Did they drill the hole? If no, they aren't guilty yet. If yes, you apply the abandonment rule.
Mm-hmm.
Was it motivated by police, victim resistance, or difficulty? That's involuntary. The result, guilty. But if it was motivated by a genuine change of heart or conscience, that's voluntary. And the result is guilty under the traditional view, but not guilty under the modern MPC view.
That is a powerful framework. It really clarifies that the law of attempt isn't just about what happened physically. It's about what would have happened if the world hadn't gotten in the way.
It closes that gap between the thought and the deed. It lets the law step in before the body drops.
Which brings me back to that voodoo doctor case one last time. We generally agree he probably shouldn't be in prison. He's holding a doll, not a gun. But if the modern law of attempt is designed to punish the intent and the dangerousness of the actor, why do we hesitate?
That's the hard question.
I mean, he intends to kill. He believes he is killing. In his own mind, he is a murderer. So if the law punishes the mind, he should be guilty. If the law punishes the harm, he should be free. It forces you to ask, what exactly are we putting on trial? The person's soul or the person's actual ability to hurt us?
That is the ultimate question of criminal jurisprudence. Do we punish the evil will or only the evil act?
Something to mull over. Thanks for listening to The Deep Dive.
See you next time.